A quorum is present pursuant to Rule 4, Section 16A for the sole purpose of taking testimony. And so we appreciate your patience while the House was in session on the floor, and obviously we can't predict the timing, so we're grateful that everybody is still around. And the clerk will now call the roll.
Representative Murr?
Aye.
Representative Allen? Representative Rodriguez? Representative Martinez-Fisher? Representative White? Representative Burrows? Representative Bales? Representative Sherman?
Here.
Representative Slayton?
And let the record reflect that Dr. Allen has joined us. Anything before we proceed? You're good to go? Then the chair lays out House Bill 2384. And Mr. Sherman, I see that you have a committee substitute, so the chair lays out the committee substitute and recognizes Representative Sherman to explain the measure.
Thank you, Chairman Murr, Vice Chair Dr. Allen, members of this distinguished committee. Thank you for the opportunity to lay out the committee substitute for HB 2384. Currently, the Community Justice Assistance Division treats all incarcerated and formerly incarcerated individuals in a similar manner. And the current law does not establish a standardized case management styles. This bill would allow the Community Justice Assistance Division to customize an individual's level of probation monitoring to the specific need of an individual, allowing high-risk individuals to receive more monitoring and lower-risk individuals to receive less monitoring than the standard levels currently offered. This bill would also provide assistance to counties who cannot help more at-risk individuals by funding support specialists. This bill creates an annual report for that, includes judges' rates of probation completion in relation to other courts and the state as a whole, which aids in their ability to make an informed decision regarding best practices and needed improvements. Lastly, this bill ties probation grant funding to the utilization of probation best practices by rewarding probation departments and judges with higher than average success rates with preference for granting funding, which then enables departments to provide training and technical assistance to other departments and courts. This has a great potential to increase probation success rates across the state. With that, Chairman Murr, Vice Chair, I almost said Bowers, Dr.
That's
Allen.
okay, any way you call me.
No, ma'am. Dr. Allen, the Dean of the House floor, and members of the committee, I reserve my right to close.
Representative Sherman, we appreciate that. For purposes of us coming back, this is our last bill of the day, and we're grateful that we still have folks with us. I will ask you just a question about the fiscal note that I think may also be addressed by some of our invited testimony from expert witness. But while it doesn't necessarily have a state impact, there was some notices there on local government impacts. And it looked like it was multiple different counties, community supervision departments. They think there'll be a monetary impact, but obviously they don't know what the amount might be. Didn't know if you wanted just to try to speak to that a little bit, and where would we be looking for those monies if it did cost extra at the local level?
Yeah, Chairman Murr, I would like to address that matter with the resource witness.
Got it. I think that will work great. I don't have any other questions right now. Dr. Allen, do you have any questions?
No.
Then we'll recognize your right to close, and the chair calls Paige Williams. And Ms. Williams, we've already practiced a lot, but if you'll tell us your name, who you represent, and your position on the bill for us.
Yes, sir. My name is Paige Williams. I represent the Dallas County District Attorney's Office, and I am testifying in support of House Bill 2384. There are several components of this bill. It's rather lengthy, but a few things that we particularly, as the chief law enforcement officer in Dallas were paying attention to and find the most powerful part of it is the fact that Representative Sherman's bill, the committee substitute, makes a provision that should a CSCD be successful and lower the number of clients they have on the reporting intervals, as they should be doing, and as you heard testimony earlier on other bills, that's their main goal, that they will not be defunded. As y'all heard many times over, the funding of these departments is.
And when you say lowering the intervals, just for clarity, pretend I'm an Aggie for a moment, I am. We talk about traditionally that would be an interval of monthly?
Depending, correct. Most probationers must report monthly. A best practices, which has been implemented in several locations throughout our state, is more of the risk assessment-based interval reporting, and that is where you get to those that have to report weekly in front of a judge, have to report biweekly, those that can report by letter only.
And so what you're saying is if we spend more time on an individualized basis to determine the need for reporting for that defendant, that probationer, then we would have some that report more frequently, but that would be countered by presumably some others that wouldn't be as necessary. And maybe over a period of time, they've demonstrated so it should change from weekly or twice a month or monthly to quarterly or by mail instead of in person, et cetera. Is that kind of the concept that you're following?
Yeah,
Okay.
that is the concept. And I'm sure there's a resource that's better.
Oh, don't worry. I'll make sure the resource witness also gets to answer that. But since your testimony spoke to it, I wanted to be able to address it with you as well.
Yes, well, and that also impacts the funding
Yes.
as they're reporting. The other thing that we wholeheartedly support is that it requires the development and training and guidance for best practices to be used by the individuals of CSCDs as well as the judges and everybody that is going to be dealing with a probationer. And training is of utmost importance. As Representative Sherman has had in several of his bills this session, the tracking and the data collection is also equally as important, because I have testified multiple times so far this session, is that you cannot have real criminal justice reform without data to back it up. Because anything that you do that isn't based on data or data-driven may or may not work. And so without more knowledge, we will not be able to continue to improve our system.
Thank you, Ms. Williams. Members, are there any questions? We appreciate you staying around today to provide testimony. The chair calls Devin Driver.
Hello, my name is Devin Driver. I'm a policy analyst for the Texas Criminal Justice Coalition, and I am for the bill. First off, I want to clarify something that was in the committee sub that I've gotten a few questions from probation chiefs that says basically someone that is considered low risk, it is there is a minimum of coming at least once a year to be basically to come to their probation officer in person. So it isn't like 1 year is the max, but it's the minimum. So the judge still has that discretion, or the probation department does still have that discretion to have them come more often. And so that's still available to them. So this bill solves three big problems, or works to do that. First off, we know that revocation rates in some practices are being performed in counties, but our system is very decentralized. And therefore, a lot of things that could be more successful, we're not really able to pinpoint. And just like the last witness stated, more data is really necessary for us to be more successful with intentional, authentic criminal justice reform. HB 2384 establishes a report that's more encompassing, including revocation rates, amongst other facets. If you guys want to ask me about that, I can also list those as well. Next, it Probation is an extremely large sector of criminal justice, and for some, it's their only involvement. And probation departments are given a lot on their plate, and they're usually the catch-all for a lot of things. And so this program, by establishing an online, basically a library to be a resource that replicates practices in successful counties into counties that have lower than average success rates, they're able to do it on their time, build it into their schedule. There's not a mandate where everybody comes on June 1st. Not every department can make that date. So by providing this, they're able to feasibly put it into their system. So we don't want to generalize everyone. We want to make sure that it's tailored to each program. And lastly, this bill and the sub works to help probation departments tackle improvement, work with more interconnectivity between counties, and lower the amount of people revoked. So, sorry. But I'll finish up in just a second. But basically allowing counties to come together and really be like, this is what works for us, and also bringing in peer support. It allows them to have that option of peer support. I worked with counties like Taylor County and Fort Bend to see what practices we could replicate. And that was one of the big things. It's like if we have the ability to do that over time, and it's not necessarily mandated, they'll be able to put this in their plan of action over time. So.
Thank you, Ms. Driver. Members, any questions? We appreciate you staying around to provide testimony.
Thank you.
The chair calls Douglas Smith.
Hello again, Mr. Chairman.
Good afternoon.
Madam Vice Chair. Doug, this is Doug Smith, Texas Criminal Justice Coalition, and we are for the bill. My colleague already spoke, so I only signed up because there were questions about the fiscal note, and I know you're going to bring up TDCJ here, and I'm sure they can clear some of that up. But I think some of the things I just wanted to point out, this does impact reporting intervals. So you already heard about that. So under parole, it could be weekly, could be under parole, it could be weekly, monthly, quarterly, or even up to a year, and even have the authority to do sort of a non-report. So they have all of those. Under probation, however, it has to be it has to be quarterly at the max. So you have to actually come in at least once every 3 months. Otherwise, the probation department doesn't get the per capita rate. And so this just expands the intervals up to a year, depending on someone's risk level. And so this should actually help probation departments lower their probation officer to client ratio. So it should be a significant help. And when I've talked to probation officers leading up to the bill, they said this could be a real help to them. In terms of the grants, I'm trying to figure out how that would hurt them, because the grants are entirely discretionary. And all it's saying in the grants is that sort of build in when you're issuing the grant awards, when TDCJ issues the grant awards, that there do be some information sharing, and that you also build in the use of peer support, which has real clear evidence of lowering relapse rates. And so just as a best practice. So that was, I scratched my head whether it would have any sort of harmful impact fiscally on any probation department, and definitely would be happy to work with the author and Representative Sherman on anything we can do to improve it. So thank you.
Thank you, Mr. Smith.
questions?
Members, any questions? Thank you for providing your testimony. We don't have anyone else who's registered to testify, but we do have some resource witnesses, and I would like to call them up. The chair calls Andrea Bodie. And don't worry, you won't be our only resource witness, but we'll put you on the spot first.
Thank you.
So if you would, tell us who you are, who you work with, or who you represent, and your position on the bill.
So my name is Andrea Bodie. I'm the director of CURB and Darren Gillespie County CSCD, and I'm here as a resource witness on the bill.
So could you speak to two parts, and you may have questions from others here, but I guess my question would be, as you are familiar enough with the bill that we're talking about right now, how would that impact your department, being that your department would fall in a rural category for the state, even though right down the road I can find you a more rural department? How would that impact a rural department? And then second, the fiscal note discussion we've had, it lists Caldwell, Comal, Hayes counties, Harris County, Bexar County, Lubbock County, Brazoria County, all larger. And then, so how does it affect you? And then financially, do you think there would be an impact to you or to a similar sized department? And I'm asking you to be thoughtful in that process because we want to understand its impacts. That's really where I am. So, yeah.
Okay. So as far as, and I'm not sure, not having talked to those directors as far as fiscal impact, I'm assuming some of it may be just the data collection itself, since it's not happening now. I would foresee that our software provider would be able to help us with that, to be able to better track that data and send it on to the state. I think there could probably be some improvements made in how our software collects that. As far as the peer support, if there are grant funds available, then that should not have a fiscal impact. I think there's a concern somewhat too as far as CSCDs possibly hiring peer support. I know, just to give you an example, in my department, there's a program that we have that I actually contract with another agency called Young People in Recovery. And the person that facilitates that program for us is actually a peer support specialist, which has really been a great thing for that particular program, because he's able to, even though he's not serving as a peer support specialist for each of the people participating in the program, he has the knowledge base and is aware of all the resources available and is able to direct them in that way. But other than that, and I'm listening to what's being said about the reporting. Currently, we do require once every 90 days in person in order to maintain direct funding from CJAD. But, there's some reworking, and there are some programs currently now that are doing pilot programs because of COVID and because of our ability to do teleconferencing for office visits. There are some other avenues being visited.
Right.
But as far as just having an obvious answer as far as fiscal impact,
We don't know.
Yeah.
And actually, in all fairness, they say it's indeterminate, as in they don't know. And so I don't want to mislead anyone to say that it appears to be a positive or negative. It's an unknown. So right now, in common practice, I would say we always default to reporting monthly. So if a probationer is going to report, I think you always kind of start with the concept of you need to report monthly.
Yes.
And that can change depending on the needs of the case, whether it's going to be at intervals that are much more frequently or less frequently. In your experience, have you seen that deviate very much at the beginning? Or is it typically you start at the monthly reporting, or do you start at a weekly reporting, or you start at 2 or 3 months reporting?
So typically monthly, just initially, we get through the intake process, the assessment process, start to develop a case plan. If they're higher risk, there's going to be more than once per month and usually at least twice a month. But as compliance is seen and, if somebody is taking care of their conditions, then we start to back off of that. So.
Okay. And I guess I'm making an observation, Mr. Sherman, about the point where where probation departments start. Do they start at that monthly process? And then the final question I would have, do y'all have any internal policies to review those? I know there's a discussion here of talking about a more individualized basis. So is it just case by case, or do you actually have a period of time where you want to look at it to say, okay, we've been reporting monthly for 6 months. Every case we want to look at and see if we're going to transition that to every other month, or is that really just case by case?
So within our own departmental policies, there's actually, it allows for lower risk cases to report less frequently, and it's up to the officer discretion.
Okay.
How is that person progressing on their own? Do they need that extra support and guidance? Even though they may be a low risk offender by our, TRAS, they still may have high needs and may need more support in the initial stages of supervision.
Thank you. That answers all my questions. Members, do you have any other questions for this resource witness?
Well, I think the questions you've asked have been very informative, and it takes me to, I think, the natural segue of what is your current caseload for the cases in your county or the counties that you are responsible for?
So I do, I don't actually look by direct numbers. I do my own, my own little special program where I formula base it. So the higher risk level, misdemeanors, we count all the same, and it's on a point system. And so high-risk level felonies are, 2 points, and then it goes down to our lowest risk. And that way, I try to manage the caseloads where those officers that have, say, our SafeP 4C program, aftercare, they have fewer cases than, the higher concentration of low-level offenders. So I try to equalize it in that aspect so that the officers that have the highest risk cases get more time credit for that. Does that make sense? So, but the cases, right now, our caseloads are low due to COVID and the lack of placements, but I would say they are anywhere from, I would say right now, they're probably 75 to 100, just depending.
For each probation officer?
Yes, sir.
They've got 75 to 100?
Yes.
Is that a manageable caseload? I mean, obviously, they're doing what they have to do, but I think I read somewhere where it's ideal to have 60.
So a lot of times in specialized caseloads that, in specialized programs, you're able to do that. You're able to, you have resources set aside for a particular caseload. So manageable. So in my department, being rural, we don't necessarily have specialized caseloads. We have a couple of sections, like we only have a couple of officers that supervise sex offenders. And then I do have a substance abuse aftercare caseload. But, our officers do all their own field work. They do pre-sentence investigation reports. They do their intakes, their assessments. So they're doing all of the work that surrounds that particular person. We don't have an assessment unit. We don't have a field unit. We don't have a PSI unit. So is it workable? Yes. Does it make it difficult to provide extra support for, people that need it that may not be in any other special program? Yes. I mean, it's really kind of difficult. Obviously, if they could be lower, when you've got higher risk and higher needs, that's ideal.
So let me just make sure I understand. As far as you're concerned, they don't need any more, you don't need any more individuals managing these cases?
As our caseloads go up, yes. But I'm fixing to absorb another position within the department because of the drop of cases in COVID. So this will be my second position to absorb right now, just kind of, trying to maintain financial stability. But the way that my department is set up, we're okay. I'm okay right now, but that's not the case, I think, for a lot of other departments.
Before COVID?
Well, I'm working, so before COVID, that's very subjective. You don't get to spend a lot of time when you have that many people that you're responsible for. Unfortunately, sometimes where maybe we should be focusing on needs, we're going through the motions of just making sure that we're in compliance and maybe can't spend as much time. So there's always a need to have more, if that makes any sense. We always want to do more, but we just try to manage with what we have.
So COVID has lessened your load?
Yes, sir.
Right. But COVID, we will ultimately be able to mitigate, the effects of COVID, and things will perhaps normalize, right? So with this bill, I guess what we're looking at is rewarding your department, your agency, by having an incentive to allow you to provide wraparound services that are fitting for your clients, so that your less risk clients versus your specialized caseloads of sex offenders. Are there any others that fit into that specialized case?
So mental health caseloads would, I don't have a mental health caseload locally. I'm trying to obtain the funding for one. But, you know, a lot of the larger departments have several different specialized caseloads.
So it's sort of like a classroom. You got some kids that need real special attention, but if you're not able to give them that special attention, then all the other kids suffer, right? Because they're all getting the same standardized wraparound services. But I think what this bill essentially will do is incentivize you and look at best practices that you have and share them with other counties and give you, I don't want to say preferential treatment as far as grant funding the process, but it certainly rewards you for successful rates that you're generating among your clients that you work with.
And I think looking at best practices and always trying to do better and implement more that's always a good thing for the field, for everyone involved.
All right. Thank you, sir.
You're welcome.
Thank you, Ms. Bodie. Any other questions? We appreciate you being here today.
Thank you for the
so much.
invitation.
The chair calls Carrie Green. And this is our resource witness with TDCJ. Good afternoon.
Good afternoon. My name is Carrie Green. I am with the Texas Department of Criminal Justice, Community Justice Assistance Division. I'm the division director for that division. I am a resource witness, and I am neutral on the bill.
So I know I have a question, but it's pretty simple. I'd like you, if you picked up on the line of questions from Mr. Sherman, is there anything that you can add to that would be beneficial for our discussion?
I guess there are probably just a couple of things that I could add. When we have a caseload report that the officers will do, and looking at just regular caseload sizes, just statewide. In February of 2020, caseload sizes for regular officers were 110 to 1. And as of August of 2020, we have the report coming up again, they were 101 to 1. And so, yes, we did have a decrease because of COVID. That was one thing. Another thing is that we do currently, by our standards, require that cases are seen once every 90 days in order to receive funding from the state for direct cases. And it basically means that to carry a case as direct and to receive funding from the state, they have to live or work within that jurisdiction and again be seen a face-to-face contact. However, the 86th session, there was actually a bill that was sponsored by Dr. Allen, House Bill 374 on video conferencing. We've done quite a bit of work around that. And then with COVID, we expanded that, and as Ms. Bodie mentioned, we have been doing supervision strategy pilots across the state. We have 15 departments that are participating in those pilot studies right now. And what we are doing is we are taking the information that we learned from COVID and the expansion of video conferencing technology, and we are putting some research behind it to see what makes sense with the intent to make policy decisions and to actually modify that 90-day interval period that is related to state funding. So I anticipate that we'll be getting some information from those soon. We do, however, have a waiver that is currently in place for all of the probation departments across the state related to that 90-day requirement, again, because of COVID. So we are funding cases based on the policies and procedures that they have submitted. So they are able to determine what that reporting structure looks like. So for example, it might be video conferencing. It could also be a telephonic contact, whatever that may be. As long as they define that in their policy and procedure, then we'll go ahead and pay for those cases. So just a couple of things that we do have in place at this particular time that we will continue to work on and can also notify you of any updates that we have there. One other thing I just wanted to mention is that the probation departments determine the differential reporting intervals for individuals under supervision by department. And then when we audit those probation departments, we will audit them based on their own policies and procedures that they set in place. But that minimum standard of the 90 days is in order to get the direct funding.
I do have one question. So in the committee substitute, there is a language here that requires reporting, including the number of revocations, and then the motions to revoke and the outcomes on those.
Correct.
Is there any reporting requirements that relate to those in any way that already are being performed?
We do have a report that we produce annually on December 1st of every year that is published for the Office of the Governor and, of course, to the legislature to look at outcomes for our diversion program funding lines. So we do look at revocations, also technical revocations. We look at placements on supervision, the number of officers that are employed.
So if we were going to ask you today, for example, could you tell us for the last fiscal year how many revocations occurred? Is that data already collected?
Yes, that information is collected. However, there are a number of outcome measures that are outlined in the bill that are not currently collected.
So you're catching at one level, but we're not getting down to the next level of
Correct.
the types of revocation. So it's already there. So that's implemented. And then one thing I just observed here, it talks about motions to revoke probation. Similarly, do you collect any information or data about motions to adjudicate?
We do not collect that information at the state level.
Okay, all right. So motions to proceed are not necessarily grouped in with that.
Right, and actually, we don't collect motion to revoke data either at the
Okay.
state level.
Okay.
So yeah.
If we have if generically we call it revocations, would that lump in both MTRs and MTPs, or it
Yes.
would? Okay. I think I have a better grasp of where we are on the data side of it. I don't have any other questions at this moment. Do y'all have any questions for our resource witness?
So just overall, you're saying it has gone from 110 to 1 to 101 to 1 as far as the entire state, the average?
Correct, an average for regular officers. And again, that's from February of 2020 to August of 2020.
And Mr. Sherman, I'm going to just interject. I think you will probably see a data analysis post COVID court activity. That's how I would describe it. When you hear the discussions about we haven't had jury trials in over a year and there's going to be a backlog of cases, I think that we're probably going to see those cases start to move. And I think you're going to see that average change dramatically because all those cases were paused, and then there's going to be an effort by the court system to move cases. And they're going to have so many jury trials, but there'll be a lot of plea arrangements that will also be considered. So I think you'll have an introduction of a lot of new probationers to the system. A year from now, we would have data on that. So I personally think that your data will then fluctuate again post-COVID, but I don't know how far you wait to analyze that data. Now, I didn't want to interrupt your question, but that's just a thought process.
No, I mean, that's, I agree.
Yeah.
I think there will be an adjustment made. And looking at the different levels of individuals or citizens that are on probation, I think, if I understand, we've got level 1, level 2, and level 3. Is that correct?
We have, based on a risk analysis, we have a high risk, a moderate list, a moderate low, and a low risk.
Okay. Those individuals, how are they classified? And I understand that when initially they are seen every 30 days. Is that correct?
It is really going to vary by department depending on what their local policies are. Again, at the state level, our requirement is that they have that face-to-face once every 90 days in order to receive funding for those cases. However, you may have a local jurisdictional philosophy that could require once every 30 days. The interval, again, it would vary based on, that particular department. Within the first year to year and a half is, well, I guess probably year and a half, even to 2 years, is typically a time when individuals are more likely to, have challenges under supervision, more likely to, be rearrested. And so a lot of times departments will have higher levels of supervision at the beginning terms of supervision, as opposed to the longer someone's been on supervision, of course.
But that will be determined by the needs of that. For instance, if it's a sexually oriented offense, he's a predator, perhaps, that person is going to be monitored more frequently and often.
More than likely. And again, it's going to depend on the policies that are established by each department.
Okay. And you've got 101 to 1 to manage. And do you see this being something that could be helpful for those departments to incentivize them to have better practices as far as servicing those that need it more and having more accountability?
Departments should be practicing differential supervision, and again, their policies should reflect differential supervision. However, I know that when we have done some audits, what we have seen is that officers will sometimes see individuals at the same level as regardless of risk type. And that can be for a number of different reasons. Sometimes if you have a low-risk person, they may be the person who wants to come in and see their officer. They want to be sure that they're getting credit for being seen. So they come in, and of course, the officer is going to document that contact. Whereas you may have a higher-risk person who is harder to get into the office. And so the officer is working really hard to get them in. And so it kind of levels out. You may see them at the same time. But again, what we do is we audit the department based on what their local policies are. And so with differential supervision reflected in those policies, then we'll give the probation director feedback to let them know that they are in compliance with their policies that reflect that differential supervision.
Thank you. Thank you.
Members, are there any other questions? We appreciate you staying around to be a resource witness for us.
Of course.
Thank you so much. And the chair recognizes that Representative Rodriguez has joined us. Thank you. We appreciate that. You came at a great time. You did. We don't have anyone else that's registered to testify, and we have exhausted our resource witnesses. So is there anyone else who's wishing to testify on, for, or against House Bill 2384? Going once, going twice. So if there, the chair recognizes Representative Sherman to close.
Thank you, Chairman Murr. Simply put, this bill ties probation grant funding to the utilization of probation best practices by rewarding probation departments and judges with higher than average success rate with preference for grant funding. With that, Chairman, I move to close.
Thank you, Representative Sherman. If there are no objections, the committee substitute is withdrawn. And if there are no objections, House Bill 2384 will be left pending. That concludes all of the pending bills that we had listed for today. Members, do you have anything else that needs to come before the committee? Is there any other further business?
Thanks for the lunch.
Absolutely. The chair hears none, and the Committee on Corrections is now adjourned, subject to the call of the chair.